when plunder becomes a way of life for a group of men in a society. Over the course of time, they create for themselves a legal system that authorizes it, and a moral code that glorifies it.
The Australian Constitution contains a unique provision to prevent and deal with corruption by any federal public servant. And it is based on the principles of the Magna Carta, Prerogative, writs of mandamus, prohibition, habeas corpus.
When a country signs and ratifies a treaty with the community of nations, it agrees to a set of principles where any reasonable person of the public might consider it done for the peace, order, and good government. Those treaties include the Convention on the Rights of the Child, the Refugee Convention, the Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment.
Any attacks on international treaties, any attacks on common law rights, the rule of law, and the principle of legality is an attack on the Commonwealth of Australia Constitution Act, Section 51, Legislative powers of the Parliament. The Parliament shall, subject to this Constitution, have power to make laws for the peace, order, and good government of the Commonwealth with respect to
a pretended law made in excess of power is not, and never has been, a law at all. Anybody in the country is entitled to disregard it. Naturally, he will feel safer if he has a decision of a court in his favor. But such a decision is not an element which produces invalidity in any law.
The law is not valid until a court pronounces against it, and thereafter invalid. If it is beyond power, it is invalid ab initio.
The incompetence and refusal, by the judges, to hear matters of treaty and/or mandamus, prohibition, amounts to an attack on the integrity of the High Court Australia, and the Constitution, in addition to the Magna Carta.
Judges protecting mates, abusing power for benefit of lawyers, judges, politicians, police. Death cult, murder by joint enterprise. Constitutional protection against corruption, Section 75(1)(5), treated with contempt, allowing corruption to flourish, especially from judges and lower courts for misconduct, abuse of power, of discretion, arbitrary and capricious interpretation, especially in matters dealing with sexual abuse of children.
Pretended laws. Arbitrary and capricious interpretation of others. These are no longer judicial officers. They are policy enforcers of the politicians, at the behest of the politicians, appointed by politicians. Australia no longer has separation of powers, of judiciary from government.
You are, at the whims of men and women, corrupted by pretended laws.